A new era for concealed carry just began. Imagine this. You walk into your local sheriff's office, background clean, trained, responsible, just trying to follow the rules. And they look you dead in the eye and say, "Sorry, you don't qualify enough." No crime, no threat. It is solely their personal judgment that determines your rights. That was the reality in places like New York and California for years. Gun owners had to beg for permission, not because of what they did, but because of how the system was rigged against them. But now, everything's changed. In a landmark 6-3 decision, the US Supreme Court just pulled the plug on that broken system. This isn't just a legal update, it's a constitutional course correction. And if you carry or ever plan to, you need to know what this ruling just unlocked. Because of this decision, it didn't just challenge the old rules, it tore them down. Welcome to Firearms Law Advisor. This is where we skip the hype, ditch the politics, and get straight into what actually matters for responsible gun owners. Today's story isn't about headlines, it's about how this one ruling just rewrote the way concealed carry works across the country and what it means for your rights going forward. Let's break it down. Part 1. The role of gun owners moving forward. The Bruen decision was a victory, but it's not self-executing. Rights only matter if we know them, use them, and defend them. Gun owners now play a critical role in how far this ruling goes. That means tracking new local laws and speaking out at city council meetings. Supporting litigation that challenges unconstitutional measures, and yes, continuing to carry responsibly, confidently, and within the law. This ruling has opened the door, but it's up to us to walk through it and keep it open for the next generation. We don't just need to celebrate a win, we need to turn it into a movement. Part 2. The 6-3 ruling explained. The case was New York State Rifle and Pistol Association versus Bruen, a challenge to New York's long-standing concealed carry law. For over a century, New York required applicants to show proper cause to carry a concealed firearm in public. But here's the issue. Self-defense wasn't considered good enough. You had to prove some extra level of risk, like being stalked or facing a specific threat. If your reason didn't meet the state's narrow standard, your application was denied. But in June 2022, the Supreme Court ruled 6-3 that this law violated the 2nd and 14th Amendments of the U.S. Constitution. Writing for the majority, Justice Clarence Thomas made it clear, if a law limits your Second Amendment rights, it must be consistent with the Constitution's text, history, and tradition. In plain English, modern gun laws must be rooted in historical precedent, not based on what current lawmakers think is reasonable or necessary. This ruling set a new legal standard, and it sent a clear message. You don't need to prove danger to exercise a constitutional right. Part 3. Legal pushback and political retaliation. In the wake of the Supreme Court's 6-3 ruling, many anti-gun politicians aren't backing down, they're doubling down. We're seeing what experts call soft resistance. That means states can't outright deny your right to carry anymore, but they can still bury you in red tape. New laws are being drafted to limit carry locations, raise renewal fees, and impose arbitrary suitability checks that make it harder to qualify, especially in urban areas. In California, lawmakers are pushing legislation that redefines sensitive places so broadly that almost any public space could be off limits to carry, even with a permit. In New Jersey and Massachusetts, legal teams are crafting new bills that appear compliant on the surface, but are designed to sidestep the ruling's intent. Make no mistake, this isn't just resistance, it's retaliation. So while the Supreme Court has set the standard, gun owners must be prepared for an aggressive second round in the courts and at the ballot box. Part 4. What's changing across the states? This ruling did not just affect New York, it sent ripple effects across the entire country. States like New Jersey, California, Hawaii, and Maryland had similar laws that required citizens to justify why they needed to carry a firearm. These states used a may-issue model where approval was subjective and often denied without a clear reason. Now, after the Supreme Court's decision, many of these states are being pushed toward a shall-issue system. That means if you meet the basic legal requirements, such as passing a background check and completing training, you must be approved. There is no longer room for personal judgment from local authorities. However, some states are responding with resistance. Instead of eliminating restrictions, they are building new legal frameworks that create more obstacles. These include extended waiting periods, more expensive and time-consuming training, and strict rules on where you can legally carry. In response to the ruling, New York passed a revised law that designates a long list of sensitive locations. These include Times Square, public transportation, parks, bars, libraries, and houses of worship. Critics argue the list is so broad that it makes legal concealed carry nearly impossible, even for permit holders. When this new law was challenged, the Supreme Court chose not to intervene at this time. As a result, the debate continues in lower courts, where legal challenges are actively underway. One thing is certain: the ruling may have set the stage, but the fight is far from over. Part 5: Text, History, and Tradition. The new legal test. The most important part of the Supreme Court's decision is the new legal standard it created. From this point forward, courts reviewing gun laws must ask a very specific question. Does the regulation align with the Constitution's original text? And does it reflect the history and tradition of firearms regulation in early America? This means judges can no longer rely on modern ideas about public safety or current policy preferences. Instead, they must look to how guns were regulated during the 1700s and 1800s. So if a law restricts things like magazine capacity, bans certain types of firearms, or limits where people can carry, it must be backed by clear historical examples from that period. That is a very high bar to clear, and it is already having a real impact. Several federal courts have struck down modern gun laws, including magazine limits and transportation restrictions, because they could not find any equivalent laws from the founding era. This new test, Text, History, and Tradition, is reshaping how the Second Amendment is applied across the country. Part 6: How this impacts everyday carriers. For most gun owners living in states with strong Second Amendment protections, places like Arizona, Tennessee, or Texas, this ruling will not change much. These states already offer straightforward permit systems or allow permitless carry altogether. But for those in more restrictive states, this decision is a game changer. You no longer have to prove why you deserve to carry a firearm. If you meet the basic legal requirements, that is enough. This restores access for thousands of people who were previously denied permits under vague and subjective standards. However, not every state is giving up quietly. In response to the ruling, some are creating new roadblocks. These include more paperwork, higher permit fees, and longer wait times. Others are introducing expanded background checks, character references, or extra training requirements to slow the process down. While these changes are being challenged in court, they show that the fight over carry rights is far from settled. The Supreme Court has spoken, but states are still finding ways to push back. For everyday gun owners, this means knowing your rights, staying informed, and being prepared to act when your freedom is tested. Part 7: What comes next? This case is not the end. It is the beginning of a new chapter in Second Amendment law. Thanks to this Supreme Court ruling, courts across the country are now being forced to re-examine a wide range of gun regulations at both the state and federal levels. That includes laws like magazine capacity limits, such as the 10-round restrictions in California and New Jersey, bans on rifles based on cosmetic features often labeled as assault weapon bans, mandatory waiting periods even when someone has already passed a background check, storage and transportation rules including strict locking requirements or restrictions on carrying firearms in personal vehicles. We are already seeing results. In California, a federal court has struck down the state's magazine capacity law, declaring it unconstitutional under the new legal test based on text, history, and tradition. And that is just the beginning. Similar lawsuits are underway in states like Illinois, Maryland, Massachusetts, and Oregon. As these cases move through the legal system, appellate courts and eventually the Supreme Court will decide how far this new framework really goes. So what comes next? That depends on whether the courts follow the precedent that has now been firmly established. But make no mistake, this was not just one ruling. It was a spark, and now a chain reaction has begun. one that could redefine gun rights in America for a generation. Part 8. Staying informed and responsible. Let's be clear, this is not the finish line. The opposition is not going away. States that want stricter gun laws are already working on new legislation that appears to follow the Supreme Court's ruling, but still makes it harder for law-abiding citizens to carry or own a firearm. And the media? They will continue to spin every court case, every headline, and every ruling to create fear, confusion, or doubt. That is why now, more than ever, it is critical to stay informed. Being a responsible gun owner today means more than just knowing how to handle a firearm. It means knowing the laws, it means understanding your rights, and it means standing with the community that is working to protect those rights for the next generation. We need to keep supporting the organizations doing the legal heavy lifting. Groups like Gun Owners of America, the Firearms Policy Coalition, and the Second Amendment Foundation. These are the individuals who challenge unconstitutional laws in court and win. But it does not stop there. Share real information. Talk to your friends and family. Help others understand what is happening, because when we stay informed and engaged, we do more than defend our rights. We make them stronger for everyone. Your voice matters. Now I want to hear from you. Was this Supreme Court decision long overdue? Since the ruling, has your state made it easier or even harder for you to exercise your Second Amendment rights? Drop your thoughts down below. I read every single comment, and hearing your stories is what keeps this channel grounded in real experiences, not just legal headlines. If this video helped make sense of what's really happening behind the courtroom doors, hit that like button. Share it with a friend, a neighbor, or anyone who carries or plans to. Because knowing your rights, that's how you defend them. And if you're serious about staying updated on the laws, gear, and strategies that actually matter, go ahead and subscribe. We've got more critical updates, real-world reviews, and smart carry insights coming your way soon. Thanks for watching. Stay sharp, stay responsible, stay safe, and I'll see you in the next one.